This is an appeal in the matter of Shorts International and Google.
Mr. Malnich, just before we start, can I just have a chat with you about the timetable?
Yes, I was just going to take on.
Okay, well you tell me then.
Does my lord not have the written timetable that we prepared? Because that would...
No, my lord definitely doesn't have it because we did agree a timetable between us, but knowing as we do that the Court of Appeal likes to set its own procedure, I didn't supply it to the court. It was more just to make sure that I knew when my learned friend was going to stop talking and I could start.
Right.
So I apologise for that.
That's all?
My lord, it's fairly straightforward. I think the proposal, with the court's permission, is that I open the SIL appeal from 10:30 till about, obviously till the short adjournment, and then from 2 till 2:45. And then my learned friend responds to that appeal and opens her cross appeal at 2:45 to 4:15. And then tomorrow morning she continues until 1 and a little bit after 2 p.m. just to 2:15. And then from 2:15 to 3:45 tomorrow we respond on we reply on our appeal and we respond to the cross appeal, and then my learned friend finishes the session 3:45 to 4:15 for 30 minutes replying on the cross appeal.
Okay.
So that's the sort of plan, but of course we're in court's hands on this.
Yes, well, I mean, you've filled the time, it looks to me like that's the work has filled the time rather than the timetable has been set by the work that needs to be done. I'm bound to tell you, I rather think this appeal can be done quicker than that, but...
that may be so, my lord. The only other thing I was going to say was that it's exactly 4 hours and 45 minutes each. So, and Fred's proposal was split down.
Okay.
So, Lords, my lady, this appeal concerns a simple but fundamental unfairness, we say. The judge accepted that Google chose the word shorts as the name of its new global service. He saw trademark uses of it, and by the time of the trial, how it had established itself very comprehensively and globally as one of the big three social media UGC, i.e. user-generated content, video services alongside TikTok and Instagram Reels, which are also trademarks, with nobody but Google calling their video service Shorts. So despite this massive use, the word had not become generic. It was never going to be generic, we say. And the judge accepted that he had to assess the position as at the date that Google commenced the acts complained of. So sort of the day before launch in the UK would be a sort of notional date. And he accepted that Google's service, he accepted that at that date, the preponderant meaning of the word shorts, as understood by the UK public, was short films. He accepted that Google's service was emphatically not a short film service. And yet he held that Google's use of shorts was descriptive and used that finding to deny the claimant any protection under any head in relation to any of the trademarks, notwithstanding that he upheld the validity of 4 of those trademarks. Those trademarks became empty letters. They couldn't be used to prevent identical or highly similar goods bearing the same brand with the identical word shorts. Now that chain of reasoning, we say, contained multiple identifiable legal errors. We don't attack factual findings save in one respect, and we don't attack matters of weight and assessment. We say that the judge's approach can be summarised in 3 principal propositions: that shorts has a single meaning that covers both the goods and services that the claimant uses its trademark for, and Google used its signs for. The claimant's trademarks, though of low distinctiveness, were saved from invalidity by their stylization. And critically, the only point of similarity between mark and sign was that they share a descriptive word shorts, with the result that there is no likelihood of confusion. The stylization that saves the marks also prevents infringement. It's a neat solution, but it contains a number of legal errors and internal contradictions. If I can say that there are a number of grounds of appeal, but if I could identify what we say would be 5 principal errors. The first of them is the shorts word is not descriptive of Google's service to a significant proportion of consumers. Therefore, it is, to those consumers, it is at most elusive. Elusive, suggestive being the right side of the line, distinctiveness. Now, the court agreed that the preponderant meaning of shorts was short films, and Google's service, with its under 60-second, vertically shot on a phone, UGC video content was not a short service. So, to a significant proportion of consumers for whom shorts means short films, Google's use couldn't be descriptive. That's the first point, and just in terms of references, that's the judgment, tab 1, paragraph 49. And in terms of the meaning of descriptiveness, I'll have a look at the case a little bit later, but it's the Technopol case at paragraph 50, which requires that people actually perceive the term as indicating a characteristic. The comparison, error 2, was conducted on a false equivalence. What I mean by that is that the judge treated the words shorts as symmetrically descriptive in both the trademarks and in the sign, with the result, in the judge's analysis, that minute differences sufficed to militate against confusion, if you see the judgment of paragraph 240. Now, this formula works as follows. The consumer sees a descriptive word used in the mark and in the sign, and therefore dismisses it as having any significance and looks for small differences that make all the difference. But of course, to work, that formula must be descriptive, and descriptiveness is to be assessed by specific reference to the goods or services in question. To take a slightly facetious example, if a consumer sees the word digital in relation to electronic products of some sort, the consumer will dismiss that, and let's say the trademark has the word digital in it. But if the consumer sees the word digital in relation to fruit of some sort, the consumer will not think that that is descriptive in any way, and therefore there must be a symmetry of descriptiveness in order for this proposition to work effectively. Now, I come up with an extreme example, but only to make the point that that was the basis for the judge's finding. And in paragraph 240, you will see the judge refers to the descriptiveness of the material. He refers to it as the material. And in that paragraph, he's referring to both the material in the mark and the material in the sign. The third error, we say, was that distinctiveness was, first of all, was allowed to pollute the comparison of the marks. Now, this might seem a slightly doctrinal or nerdy objection, but there's very good reason for it. Because in the overall analysis, the multifactorial assessment that must take place in the trademark infringement case, the various factors have to be weighed and assessed and irrelevant factors have to be left out and relevant factors have to be included. But what you can't have is distortion of any factor. So you can't have double counting of a factor. And that's effectively when you bring in distinctiveness as part of the purely comparative exercise, you are inevitably double counting, as well as also corrupting the pure comparison exercise. As the Court of Justice has made clear, distinctiveness is not a comparative criterion. A comparative criterion, the process of comparison is simply comparing marks visually, orally, and conceptually, and according to the parts that have dominant and prominent significance. Now, that's the third one. The fourth is that the judgment was internally inconsistent as between the 10.3 and 10.2 findings, 10.3 being the reputation, extended protection, dilution, and 10.2 being the likelihood of confusion. And for 10.3, the judge held that if the claimant had a reputation, it was amongst consumers of short films. And at that point also applied to 10.2, because you will recall that in the Interflora case, Lord Justice Kitchen, as he then was, made it clear that the basis for the average consumer is to take account of consumers to whom the mark is particularly distinctive. So the mark, our mark, is registered for cinematographic films. That is the average consumer. That person, in relation to a valid mark, is taken to consider that mark to be distinctive to some extent, but certainly to be steeped in the meaning of the mark indicating short films. And it's that person to whom the sign is exposed and who must assess the meaning of the sign in relation to the goods or services that Google is providing. And the final one is we say that the judges implicitly recognized dilution, and his existing finding of fact is a finding of dilution in paragraph 258. This is where he said, Google's activities have moved the center of gravity of the use of the word shorts away from short films. Now, that concession is critical, we say, because it confirms that before Google's, the center of gravity was short films, which is precisely why Google's use of shorts for a UGC service was not descriptive. And secondly, displacing the center of gravity of an established mark overnight is a paradigm case of dilution. That's swamping. So just before I start with short foray into the law, standing back, one of the world's richest and most powerful companies was attempting to catch up with the other video clip platforms, needed a name in a hurry, carried out a trademark search, and discovered these trademarks. This is the judge's finding when he found against the defendant on honest practices. Undeterred by that, they pressed on and adopted that name months later. And the service has become very commercially successful. The trademark has been used as a trademark. And yet the judge held that the trademark owner could do nothing about it because the word was descriptive. Obviously, my learned friends have points to make on validity, but as a matter of pure infringement, it was a most unfair outcome, because whilst we kept our trademarks, we were not allowed to use them or able to use them against a business that was offering similar or identical goods and services and doing so, in effect, under a highly similar trademark. So, my lords and my lady, I thought the best place, and really the only place, to look for the law on the various provisions, insofar as they concern infringement, is the Supreme Court's recent judgment in the Iconics case, which you'll find in your bundle of authorities. It's the last tab in the bundle, because it contains a number of relevant points. This is the case about post-sale confusion in relation to trainers, but it's also, Lord Briggs has a very useful summary of the approach. If I could just start with the statutory provisions without actually needing to turn to those in any different place. Some members of the court will be extremely familiar with these, but it's worth just revisiting them. Page 687 of the bundle, 628 of the report. Paragraph 21, where section 10.2b is cited. A person infringes a registered trademark if he uses in the course of trade a sign where, because the sign is similar to the trademark and is used in relation to goods or services identical with or similar to those which the mark is registered, there exists a likelihood of confusion on the part of the public, which includes the likelihood of association with the trademark. Lord Briggs then cites the directive. Now, the critical point about this is, in the statute itself, the only thing that's actually mentioned is similarity of marks and identical or similarity of goods or services. Now, of course, we'll come to the factors that have been developed in the case law. But it's significant that those two factors are the ones actually in the statute, and they're obviously very important. Now, the next paragraph it's worth looking at is section 10.4 of the Act, which you'll see extracted below paragraph 24. For the purposes of section 10, a person uses a sign, affixes it, offers, imports or exports goods, uses the sign as a trade or company name, uses the sign on business papers or in advertising, uses the sign in comparative advertising. Over the page, the list in section 10.4 is non-exhaustive and transposes into United Kingdom law Article 10.3 of the directive. If I could just skip the next paragraph, go to E, identification of the sign used by the defendant and a determination of the goods or services, if any, in relation to which the defendant is using it. All acts, paragraph 27, of infringement under sections 10.1 to 10.3 are based on the sign as used by the defendant, which must be compared with the claimant's registered trademark. And the identification of that sign must be conducted from the perspective of the average consumer. The court should ask, what would a significant proportion of persons with the characteristics of the average consumer perceive the defendant's origin identifying sign to be? And then we come to a passage which is quite material to the appeal specifically, and that relates to the average consumer. The average consumer includes any class of consumer to whom the guarantee of origin is directed. The characteristic of the average consumer have been considered in several cases. Lord Briggs cites Arnold L.J. in the Lidl and Tesco case. So these points come from there. The average consumer is a legal construct and a normative benchmark. Ill-informed and careless ones are excluded, as are the excessively careful. The average consumer is not a single hypothetical person nor some sort of average. They represent consumers who have a spectrum of attributes such as age, gender, ethnicity. And this paragraph here, this passage is important. It follows that assessment from the perspective of the average consumer does not involve the imposition of a single meaning rule akin to that applied in defamation law, but not malicious falsehood. Thus, when considering the issue of a likelihood of confusion, a conclusion of infringement is not precluded by a finding that many consumers, of whom the average consumer is representative, would not be confused. To the contrary, if having regard to the perceptions and expectations of the average consumer, the court considers that a significant proportion of the relevant public is likely to be confused, then a finding of infringement may properly be made. There's a few other characteristics there. Paragraph 20, the average consumer rarely has the opportunity to make direct comparisons between trademarks and must instead rely on the imperfect picture. G and H are the last two parts that I need to look at quickly. G is, it's sufficient for the purposes of this appeal to state that the test for the similarity of the sign to the mark was set out in Sabel. The global appreciation of the visual, oral, or conceptual similarity of the marks in question must be based on the overall impression given by the marks, bearing in mind, in particular, their distinctive and dominant components. And then the likelihood of confusion, this is the passage where Lord Briggs sets out the, certainly to trademark lawyers, familiar list of factors that are taken into account at the likelihood of confusion stage. You can see that in 38. There's citation of Arnold, J. and Matt group, but these are familiar factors. It's a global assessment, judged through the eyes of the average consumer, perceiving a mark as a whole. The visual, oral, and conceptual similarities of the marks must be assessed by reference to the overall impressions. It might be dominated by one or more of its components. There is also a situation where they might have an independent distinctive role within a composite mark. A lesser degree of similarity between goods or services is set by a greater degree of similarity between marks, and vice versa. Greater likelihood of confusion where there's higher distinctiveness, and so on. Now, I cite those.
Corollary of H, greater likelihood of confusion where highly distinctiveness must be a lesser likelihood of confusion with less distinctiveness.
I think that has been stated in a number of cases, including by Lord Justice Arnold in a case whose name is escaping me at the moment. I think it might be Leicester. Sorry?
You agree?
Yes, I do agree. Another case which might be thought to be relevant on this is my Lord's own judgment in Nicker Ventures. The Vape Co. versus Vape & Co., I think it was, for vaping products, where my Lord suggested that where marks lack distinctive character, well, not lack, where the distinctive character is low, then that has to be factored in somehow, and we accept that. It has to be factored in, but that's a bit different from what happened here.
When is it factored in?
That has to be factored in the overall assessment.
Right.
That's when it comes in. That's when distinctiveness comes in. That's when the average consumer, that is clear
Sorry,
from
the overall assessment of likelihood of
Yes.
confusion.
Yes. So just looking at what the
So
schema
this
we've
list
been,
of factors.
yes, it's what you look at the comparison of the goods and services, you look at the comparison of the marks, you look at the average consumer, who that is, identify. You need to identify the sign probably as the very first stage of the exercise, and then you put them all in the pot, and that's when they have to be weighed. And we make no challenge to the weight, and we're not saying that it was illegitimate to take into account distinctiveness. Far from it. It's compulsory to take that into account. You've got to have some assessment. With highly distinctive marks, it obviously is a point in favour of infringement. But and with low distinctive marks, it might be a point against, or it should be a point against, depending on the case. But one has to be very careful with marks that have low distinctiveness, because of course the defendant's mark may have low distinctiveness as well, or sign may have low distinctiveness as well. I'm not saying that's this case necessarily, but the case law is full of cases where both mark and sign had low distinctiveness. The Vape Co. and Vape & Co., assuming a valid mark, there's probably going to be a likelihood of confusion because consumers can't tell or won't remember whether it's the ampersand or whatever it is that is making a difference. So,
Mr. Mallard, just to be clear, you're referring to a case which you said I did. I'm sure you're right. I'm afraid I have literally no memory of it, whatever. Is it in the bundles?
I believe it's cited in the judgment, but not in the bundle of authorities. We can certainly go to it in due course.
My lord, as it happens, I have a copy of it if my lord is interested.
I don't think Mr. Marnich is referring to it.
Yeah.
Yes. I mean, given what Mr. Malinich has said, I will now refer to it. Shall I hand it up now or shall I sit down and be quiet?
No objection to that.
Yes, I will.
So, looking at the passages from the Iconics case, two points that we wish to highlight. First of all, the approach is a structured one, and this isn't out of a consideration of doctrinal tidiness. It's simply so that no factor is transformed automatically into a super factor, and no factor is double counted. It's important that each factor is properly weighed in accordance with its applicability to the case. And we say the second point that emerges is that when it comes to a likelihood of confusion caused by a consumer perception, there's a recognition, an express recognition, that not all consumers have the same perception, that there may be a single meaning rule point. There may be some for whom a mark confuses, even if there are others for whom it does not. In fact, incidentally, the same point is made by Kitchen LJ, as he then was in this court, in Interflora. It's at tab 15, paragraph 129. Rather than read that out, it's the last 7 or 8 lines. Of course, the court must ultimately give a binary answer from there to the end. There's a sort of, there is a lower level. It must warrant the intervention of the court. In fact, you could find 4 or 5 people who are still not excessively careless or excessively careful, who would be confused. Perhaps that wouldn't warrant the intervention of the court because it wouldn't be something worth worrying about. But subject to that, if there's a significant proportion of the relevant public, to the extent that the court can make that assessment, that suffices. Now, if I can then turn to ground 1, which is the meaning of shorts and its consequences in this case. Lord, I wanted to just, because this, I'm opening the appeal and because validity is to come, I just wanted to briefly explain how descriptiveness worked in this case and how it arises on the appeal. So descriptiveness comes in, or came in 3 different ways. The first of them, making matters in sort of logical order, was invalidity. And that was an assessment, according to Technopol and lots of established cases, of the degree of descriptiveness of the word shorts, but also the other aspects of the signs, shorts TV, being a word in 3 of the marks, in relation to the specific goods or services. And that's really important. The Lords keep that in mind in due course, because the assessment of distinctiveness must always be made by specific reference to the goods or services in question and not in the abstract. So that is a sort of unilateral focus on the claimant's trademark. On The other way that it came up, it doesn't arise in this appeal, was on honest practices, the descriptive use defense. Google ran descriptiveness as a defense, and in order to open up that defense, had to establish that their use of the sign in relation to their own goods and services was descriptive. That was also subject to the honest practices proviso, which is subject to a number of, there's a lot of case law on that, but the judge in this case found against Google on that, principally on the basis that it was a reasonable inference that they had done a trademark search, identified the claimant's trademarks, and pressed on. We wrote to them, complained when they first launched in India prior to launching in the UK. So the judge held that the sign was descriptive, therefore in principle the defence was available, but it fell down on the honest practices. And it's notable that Google, although they've appealed I think every adverse finding in the case, they've not appealed this. So that's a focus on the defendant's side. Coming to the relevant approach, which is infringement, this has to be a sort of bilateral or symmetrical descriptive significance for both mark and sign, for both the goods and services covered by the mark and the goods and services distinguished by the mark. Oh, sorry, by the sign. When I'm using sign, that's the defendants and mark, claimant's mark. So this is unique in the sense you've got to have both. It's got to be descriptive in relation to both. Now, when you are dealing with, and I'm not going to turn to vape company, I'm simply using it as a narrative vehicle, but if you have the word vape, both claimant and defendant are using the word vape in relation to vapes or vaping products, there is obviously a descriptive significance in relation to both mark, the goods and services, the goods of both mark and sign. But where the goods and services differ quite substantially, then the position is far from straightforward. And we say that is one of the most significant problems with the judgment. Now, what do we mean by descriptiveness? I said I'd look at Technopol, and I'm not sure that it is in the bundle of authorities, but it's in the judgment, fortunately, and I don't think there's any issue taken on whether it is, right? Oh, sorry, it is here. Yes, good. Oh, that's right, it's this one, isn't it? It's Polish name. Yeah. Okay. So it's paragraphs, it's tab 8 of the bundle of authorities. And if you turn, please, to page 186 of the bundle, paragraph 50. Actually, the highlight goes over the previous page. If I could just pick it up at 49, please. Now, this is talking about validity, but there's no reason to suppose that descriptiveness means a different thing in different contexts. It might have to point to different goods or services, but it means the same thing. The situations covered by Article 7.1c of the regulation are those in which the sign for which registration as mark is sought is capable of designating a characteristic of the goods or services. The term kind, quality, quantity, intended purpose, value, geographic origin, or the time of production of goods or rendering of services, or other characteristics. The legislature made it clear first that the kind, quality, quantity, intended purposes, etc. must all be regarded as characteristics. And secondly, that list is not exhaustive. Now, the fact that the legislature chose to use the word characteristic highlights the fact that the signs in Article 7.1c are merely those which serve to designate a property easily recognisable by the relevant class of persons in respect of which registration is sought. As the court has pointed out, a sign can be refused registration only if it is reasonable to believe that it will actually be recognised by the relevant class of persons as a description of one of those characteristics. It must be reasonable to believe that it will actually be recognised by a relevant class of persons as a description. Now, that is what we're looking for when it comes to descriptiveness. Nothing particularly surprising. The only part I really emphasise is the sort of degree of conviction. It must be reasonable that it will actually be recognised. And of course, the fact that it specifically relates to the goods or services in question. Now, at paragraph 58 of the judgment, the judge held that at each relevant date, the meaning of shorts was not limited to short films, but also included other short-form audio-visual content. Now, we don't challenge the factual finding as such. The error is legal in the sense that the judge misapplied the consequences of that by holding that that was a single meaning understood by all consumers. And that is the error that the judge made, because he also held that the preponderant meaning, and this was conceded by Google, it was contended for by us, it's shown in documents, plain as day, the overwhelming meaning was short films. So that's the dictionary meaning. It's the meaning which you'll see in Annex 3 in the supplemental bundle, which I'll take you to in a moment. It is clear that that is the dominant meaning.
Which paragraph of the judgment?
Sorry, 58, my lord.
58.
I think I've got that right. I hope I've got that right. Yes, you could, and he records the concession at paragraph 49.
So this is 58. 58 says, I conclude, this is at tab 1 at page 21, at least of my PDF. I'm talking about page 18 of the paper.
Yeah, that's it.
I conclude that as of dates, the meaning of shorts was not limited to short films, but also included other short form video things.
Audio-visual content, yeah. But if you, as
But
sorry.
does that mean, do you say that's a finding that all average consumers have that? In other words, they all aware that it is not limited to short films, but includes other short form audio-visual? Or is that a finding that some consumers think it means one thing and other consumers mean the other thing? Because you seem to be assuming one interpretation, and it's not obvious to me which the right interpretation is or whether the judge did what you say the judge did.
My lord, with respect, you put your finger on the exact problem with the judgment, because it could only be if he was holding that all consumers, or practically all consumers, had that meaning, that he could hold that the Google service was descriptive by the word shorts. If he didn't, and he shouldn't if we say, because the consumers, of course, would have a range of different understandings, but principal meaning being the one that they would, of course, mostly have, they could not think that that described the Google service. So that's the point. It is unclear. He doesn't.
I'm trying to understand what you say paragraph 58 means
Yes.
at the moment, and whether you put to the judge what you're now putting to us.
Well, we put to the judge that the meaning was short films,
Right.
and that therefore, and that Google's service was not descriptive. That was very much our case. The judge's solution to that was to look at the annex of uses, which showed a preponderant, 90% or more, use of shorts where it was clear that it referred to short films, and noticed that there had been some use more recently. In fact, he says, it's in the paragraph before that, I need to determine what the position was as of 20 February 2018, 19 and 21, and he says most of the material is after 2018. And he says, that there doesn't seem to have been a significant shift as of 20th February 18, 19 or 21. And he concludes that as of those dates, that it also included other short form audiovisual content. So the question that arises is exactly the point asked me, my lord, in the sense, to whom was that meaning understood? Because let us say, I think he refers to Mr. Harbinson's evidence. Mr. Harbinson, I think, who used to work for Channel 4. Let us say that Mr. Harbinson considers that it bears that broad meaning. So then he can say, when he sees that sign used in relation to both the trademarked goods and services, which are short films, and the goods and services of Google, the UGC sharing service, he can say that's descriptive. But that's not everybody, and far from it, when the finding was also that the preponderant meaning was of short films.
So, help me, what findings of fact are needed to make the point that you're making?
We say that there are two findings,
And do they exist?
neither of which we challenge, because what the judge ought to have said was, in the light of these two findings, I find that a significant proportion of people would not see the Google service described by the word shorts. Now the finding...
Sorry, where is...
Yes, it's 48. Yeah, so if you take 49 of the judgment, parties were agreed in the case of Google, subject to the question of whether short films can be sufficiently defined, that these materials showed that the predominant use of the term shorts was to mean short films. Can I just show you very briefly what he means by these materials? I'm not trying to go into the evidence, it's just to explain what he's talking about. You will find that in the supplemental bundle behind tab 10. And there's a colour-coded table.
Yes, I think your skeleton took us to
Yes.
this. So
And
you say 90% of it's
Well,
green.
we haven't, I don't think we've mathematically
Okay.
determined it, but the preponderant meaning anyway was agreed. So that's the first fact finding. There was a finding that the preponderant meaning
Yeah.
was that over time. And if one looks at this table, which was prepared by Google, so that they relied upon this, you can see that that's broadly speaking supported by the colour code. Now, that's the first finding, but the second finding was the one that I took you to in 58. So the meaning of shorts was not limited to short films, but also included, so we're not trying to come up with a dictionary definition here. What we're trying to understand is what is the meaning that would be carried in the mind of the relevant consumer. And that sorry?
I'm still trying to understand what I think you're saying that you've got the findings of fact you need, but I'm trying to identify what it is that you say you have.
Yes.
Here. As I understand it, the thrust of your argument is that there is at least a significant proportion of people for whom shorts means short films. I can't quite see that, and possibly only short films, I don't know, but I can't quite see that in these findings here.
So when the judge is referring to the meaning, he doesn't ascribe it to a segment of the population. That's true. He doesn't say X number of people hold this and Y number of people hold that. He just simply talks in terms of an abstract meaning. Now, and those are findings which we do not challenge.
But what do you say you're not challenging?
We're not.
Now you've drawn this distinction, I don't understand what you're
Well,
saying. You
we're
agree
not
with.
challenging that the preponderant meaning, so the main meaning was short films. Yes, that is the main meaning.
But that's not answered the question. Mr. Mallett, I don't think it's that complicated.
Yeah.
You're running an argument that says that this is about segments of the population.
Yep.
What I don't know at the moment is what you say the judge found as a fact on which you're basing your argument on. Or you say the judge found.
Well, when the court holds that the preponderant meaning of the mark is X, we say that is akin to a finding that that is the view held by the majority of the population. That must follow as a matter of common sense. When the judge then refers to evidence that shows some development and evolution of the meaning more recently, and that's what he holds, he looks at particular dates, what he's then holding is that the meaning has evolved. But it would be nonsensical to then infer from that that the meaning has evolved for everybody, and in particular has displaced the main meaning. This is the key point.
Why couldn't all the segments of the population be aware of both the predominant meaning and the less predominant meaning?
Because the newer meaning, or the less predominant meaning, must displace, because it's included within, sorry, I've not expressed myself well. The short films meaning is included within this broader meaning. So it's not a sort of completely different thing. It's short films is audiovisual content. So if you take that as a starting point, you must be saying that the general meaning has displaced or subsumed the short films meaning. And there isn't that finding. I mean, it is suggested on the other side that there wasn't evidence of the proportion who know the short films meaning. But in my submission, that is really to look at things backwards. It was held to be the predominant meaning on the basis of evidence in the case and concession. Therefore, if you're going to argue for a special meaning being held by practically everybody, which is the Lord's hypothesis, you need to show that. And of course, that wasn't even attempted because it wasn't correct. Now, there's a further point here, which is that even if you were to say that the broad meaning was established amongst all of the relevant population, it was still not the same species within the genus, the broad genus of meaning, as short films. Let me just explain what I mean by that. The meaning that the judge adopted in paragraph 58 was not limited to short films. It included other short form video content. So in other words, it was short films plus any other audiovisual content. That's the broad meaning. But that doesn't mean that the consumer of the trademark, who is taken to see it as meaning short films, is seeing that same meaning in the use of the sign, even though it might be strictly covered by the descriptive term.
Sorry, are you saying that what
So
the
that
judge
should-
should have done is deduce from the fact that the preponderant meaning was short films a conclusion that at least a significant proportion of consumers would view it in accordance with that preponderance.
Yes, so that's our starting point.
But you have to, the judge hasn't done that process.
There are other parts
and
of the...
you have to show that he was in error in not doing that.
Well, there's another part of the judgment I need to show you, where I will say he did actually do that. But what I'm identifying now is, yes, that is my primary argument, that at least a significant proportion of people understood the mark to be the predominant meaning.
When you say that, as I understand, what you have I got this right? Mr. Marlich, your argument, the factual premise for your argument, that because you keep telling us you're not arguing the facts, is that there is a large segment of the population for whom the word shorts only means, in this context, short films.
Yes. Now,
That's what you
Yes.
said the facts are, and the judge doesn't find that fact here explicitly.
he doesn't address it.
You're going to tell us that later on you say he must have thought that, but you've shown us the passages in this bit of the judgment, and they don't say those words anywhere.
They don't say those words because the judge saw this case as a single meaning case. He saw that there was one uniform body of consumers that understood the mark as this, or at least that was the implication, because he had to have held that in order to find the Google use descriptive, which he repeatedly finds. But unfortunately, he doesn't actually explain how it's descriptive anywhere in the judgment. That's part of the problem. So one is left with a bit of an inference there. But my lord, I make a few other points on this.
It's not very difficult to think that the word shorts is rather descriptive of things which are short.
Yes, absolutely. Yeah.
We might say that's what this case is all about.
Well, at that level,
and that is your problem, frankly.
at that level, it's suggestive of short things, yes, short something, but it is not descriptive in relation to these goods or services. A second point is this, my lord, and this is very important. You'll recall that I referred to the Interflora case for the proposition that you must assess matters from the perspective of the consumer of the goods or services to whom the mark is particularly distinctive. The starting point, actually, even before that, is your average consumer, identified by Lord Justice Arnold in Skykick, is a person taken to be familiar with the mark. So this is a person who is effectively our customer, if you want to put it in simple terms, notional. The person familiar with the mark who considers it distinctive in relation to those goods and services. So
Does the law say
short films
and-
consumer.
Does the law contain the words "and considers it distinctive"? Because they sound
Yes.
new to me.
Sorry, I'll take you to that because I did, I glossed over that. If you look at 15 of your bundle of authorities and page 419, paragraph 123. It's important to have in mind that the issue of a trademark's distinctiveness is intimately tied to the scope of protection. For example, it's well established that in assessing an allegation of infringement arising from the use of a similar symbol, the court must take into account the distinctive character of the trademark. There'll be a greater likelihood of confusion where the trademark has a highly distinctive character, I would say, as a result of the use. It necessarily follows that the court must therefore have regard to the impact of the accused sign on the proportion of consumers to whom the trademark is particularly distinctive. And that's an extension of a more basic principle, which is that the average consumer, and you can find this in the judgment himself.
Just a minute, Mr. Marlich. That doesn't mean, does it, that the average consumer has to think the mark is particularly distinctive? That's not what that means, is it? It means that the people in the average consumer you're dealing with is that portion for whom that mark, however distinctive it has whatever distinctiveness it has.
Yes, I think that's fair. Yes, that's right.
So it doesn't suddenly turn a descriptive mark into
No,
a distinctive mark.
No, it doesn't. But one thing is clear, is that my mark isn't registered for UGC social media sub 60-second clips. Right? My mark is registered for cinematographic films, short films, and so on. My consumer is the person whose head is ringing with that meaning. That is the meaning that they have. That is the preponderant meaning, according to the judges.
So your case is that your mark is registered for the very thing your mark is descriptive of.
My lord, my whole mark is not descriptive of any of my goods and services, my
The
primary
word
capability.
shorts, the whole point is that you say shorts means
Yes.
short films, and you're
The
emphasising.
word
that
shorts,
the-
yes, the word shorts on
short
its
film.
own is descriptive of some goods and services within my specification. But here we're talking about what is the perception of meaning by the average consumer. The average consumer is identified by Lord Justice Arnold in the Skykick case as being a person familiar with the mark who encounters the sign in use. And that is mentioned by the judge. Just find you that. Yes, it's paragraph 167 of the judgment, page 46. So this person, this segment of the population, is going to be focusing on that meaning. By the way, my marks are, trademarks are registered for the beginning of the judgment. So page 10 of the judgment, just to see what it's registered for, what they're registered for. The earlier marks are registered for class 9, 38, and 41. And broadcasting, entertainment services. And we were relying on, and of course have used in relation to our short films, channels and so on, our short film activities. And then the later mark, the Shorts TV mark, has a specification, which we don't need to go to for the moment. So we say that when in 167, the average consumer is identified, they're first of all identified as a consumer of the relevant goods and services, who's both familiar with the trademark and exposed to and likely to rely upon the sign. And as my Lord Justice Burse suggested, if the mark has any distinctiveness, they are people who are aware of that distinctiveness. I put it no more than that at that level. So in the light of the finding that there's a preponderant meaning of short films in general, and in light of the finding, in light of the legal proposition of the identification of the relevant consumer, it is a, we say, obvious result that such a consumer is not going to see the Google use as descriptive. It's as simple as that. And even if it is seen as descriptive in the sense of being elusive or suggestive of something short, that is not enough, because that's not descriptiveness in the same way as the claimant's mark. So for the claimant's mark, it means a specific thing. Short films, there are short film festivals, there's short film awards, there are short films. They have a very important role in the industry for, in terms of nurturing young directorial and acting talent and so on, production talent. And they have their own awards ceremonies and their own festivals. People know what short films are, we say. And when they see shorts, meaning that they're the people whose eyes and ears are trained upon the Google use. And then they see what that is. That's not a short film service. Now, even if they think, right, okay, but shorts must have been extended in meaning, why they would think that is neither here nor there. It's still not descriptive in the same way that short films is descriptive. Shorts is descriptive of short films. So
This point about descriptive in the same way, you're relying on technical.
yes. I mean, I'm relying on that generally as the meaning of descriptiveness, yes. The sort of degree of immediacy and the degree of conviction that you must have with respect to a descriptive sign.
Why does it have to be descriptive in the same way? What's that got to do with it?
because this is because of the way that descriptiveness works in an infringement case as opposed to validity or the honest practices. So in validity, a mark may be descriptive as one of its possible meanings, and it may have a number of different ways of descriptiveness. So for example, double mint is the classic descriptiveness case from the Court of Justice. Double mint, does it mean two kinds of mint, twice the amount of mint, or two kinds of mint stuck together? Who knows? It doesn't really matter, because if any of those meanings will do to knock the mark out from validity. Right? But this is different, because in an infringement case, the consumer is taken to be aware of the descriptiveness of the earlier mark, but it's not complete descriptiveness, because otherwise it's invalid. And to discount that when encountering the defendant's sign. So to think,
So, sorry. You said the consumer is taken to be aware of something of the descriptiveness. You didn't show us a case that said that.
perhaps I didn't express myself well. The consumer is taken for it to have some distinctiveness, because this is a
You showed us that.
yes. So the mark is presumed valid. I mean, obviously validity is to come. So for this part of the case, and at this stage, the consumer understands the meaning to be what it is in one context. My lord asked me, why does it matter whether it has the same meaning in the mark and the sign? And the reason for that is because what goes on in cases where the court discounts the descriptive shared element is a relational formula, a relationship between the goods over there and the goods over there. The goods covered by the mark, goods covered by the sign. If they aren't the same, then why would the consumer discount them? Why would the consumer think that it's got no significance? On the contrary, because they will think, I'm just trying to think of the example. If you have the word bitter in relation to bitter beer, right, and the word bitter in relation to bitter lemon. Now, bitter is a type of beer. It's not, strictly speaking, descriptive of the taste. It's a type of beer. Whereas with lemon, it's bitterness as a taste. Now, it might be that if the consumer of analogies are so dangerous in trademarks, I can see my slightly. But the reason why a consumer would discount bitter when it comes to another bitter beer is because they understand bitter means a type of beer. But when they are given something where that word has a different significance, or where it might be suggestive as well, then there's no reason for them to discount it, because they are the consumer of the beer. That's the point. I mean, it's a bit different here, because of course, you know, we're dealing with different sides, we're dealing with different goods. I mean, as an extreme example, the reason why vape gets discounted in Vape & Co versus the Vape Co is because it's descriptive in the same way of the same goods. And absent that, there's no reason. There must be a symmetry between the meaning. And so this is why, even within the judge's broad meaning, it can't work as a formula. Now, the only other point I was going to make on this was to say that even within the judge's broad meaning, it didn't describe what Google were offering, because whilst it might be said this is all just audiovisual content, that's not quite correct. This is fundamentally a social media service, an interactive content service involving user-generated content and engagement. Yes, there are moving images on a mobile phone screen. But to describe it as simply short form video entertainment is, in my submission, vague to the point of being not useful. And so we can see that by virtue of the table of use that Google submitted, the annex table in tab 10 of the supplemental bundle, which you'll find at page 114. And what we see is that even in relation to the extension of the meaning, and that's the examples in red, which were said to be the sort of examples of extended meaning. The orange was, sorry, there's a key on page 1. Green is reference in the context of short films. Red is reference to something other than short films. Orange is context unclear. And what you have there is nothing that describes anything that describes Google's type of service. I mean, what we have is some development that isn't short films, but that's not the same thing as describing the sign here. I mean, broadly speaking, what was missing from the judgment here, if one looks and distills all the points I've been making, is a total failure to assess descriptiveness in relation to the Google sign from the relevant perspective. That's really what it comes down to. Whether you look at it in terms of a significant proportion, whether you look at it in terms of judicial reasoning, it was clearly, there was clear reasoning that explained how it was said to be descriptive in relation to short films. Indeed, it was conceded. But there was not a similar exercise when it came to Google's service. And that was important because Google never explained it either. They came into court saying this is a descriptive word, even though it had a logo and, as we'll see, it's emblazoned all over the use as a trademark. There was no principled analysis as to how it was said to be descriptive.
And forgive me, possibly being slow, where does this take you if it's right? Because we're clearly on
Yeah.
infringement
The
at
table.
this stage.
Yeah. Oh, you mean
Not-
longer term in the case?
Not invalidity. Isn't it all about likelihood of confusion?
Yes.
Then your point about the difference in the services,
Yeah.
mightn't that reduce the likelihood of confusion?
It would mean that they're not identical, except that would depend on my trademark, because my trademark is registered more broadly than my actual offering. I've got other goods and services there, I've got entertainment services and things like that. But yes, my lady's instinct is right. Ordinarily, you don't find a claimant saying that there's a difference between the services. I mean, really just to draw out the distinction for the purposes of this error. So because I say that you have to have some analysis of, it has to be descriptive in relation to Google's use, but it's never explained by the court how it is descriptive. I mean, other than the point put by my Lord Justice Burse, which is could be descriptive of anything short, but that's, we'd say, pretty unsatisfactory, because that's simply elusiveness. Yes, it's short, but it also isn't
Isn't that
clear.
what the judge meant by short form audiovisual content? That was a description of what Google were doing.
Yeah, at that level of generality. Yeah.
So
That
the
is-
judge, so didn't the judge did identify what it was descriptive?
Well, no, because I say that that's just simply at a level of suggestiveness. That's not describing the service. It's not describing what it is. Because again, it operates as a descriptive term in relation to a specific type of film. It's in a dictionary, you've got festivals and so on. So that is a meaning, right? To what extent does that meaning get projected onto the Google use. Now, there is another point to be made here about the Google use, which is that one would be forgiven for thinking that all this talk about descriptiveness on the part of Google, they must have just been using it descriptively in the text of articles and things like that. But of course, that is not the case. It was being used front and center as a trademark. So to the extent that one was to say, well, okay, there's a descriptiveness aspect to it, it doesn't really matter because it was being used as a trademark in a very classic sense. Now you can see this from the beginning of the judgment. I've actually just brought enlarged copies of the photographs there because I don't think you can see them clearly in the judgment. I'm able to hand these up. It's 3 copies. These are just larger copies of the images in the first few pages of the judgment. And the judge walks through the various screenshots. So just to introduce that, if you look at pages that you just showed me, page 9 of the judgment, the pleaded case against these signs was in paragraph 23. The claimant complains about each instance of the use of the word shorts in or associated with the YouTube Shorts service. That includes the use of YouTube Shorts itself, and as can be seen from the illustrations above, the use of the word shorts alone and alongside YouTube Shorts logo in various manners. Now it's these pictures that I've just handed up. Now, the first of them is a desktop version. I should say that the principal manner of exploitation of the service is mobile phone. And although the 3 scenarios that were in being that were looked at were desktop, smart TV, and mobile phone. So this is the desktop version. You can see the YouTube logo up in the top left. And below that, down the side, home, shorts with a logo, subscriptions, the sort of TV or play button, history. Then over the page, you've got, if you click on shorts, this is what you get. A red logo, sort of a scroll of film or something, I don't know what it's supposed to be, and shorts. That we say is quite clearly trademark use. The judge agreed that it was at least in part trademark use. And
I mean, I must say, looking at the front page, you showed us where it says shorts under home and above subscriptions. Shorts is a trademark, so is subscription.
no, it's not. Well, I mean, this was a point run by Google that if it's surrounded by non-trademark words, then it's not a trademark. But one can see very clearly as you progress into what's called the journey through the site that point evolves. So you've got shorts as an independent logo that's obviously said to, is trying to be reminiscent of the YouTube logo, I suppose, in terms of colour and the play device. Shorts, and then you've got an individual screen. And interestingly, even on a desktop, it's in vertical mobile phone type format. And over the page, you've got Surfing Sydney, and you see you've got what's called the bug on the actual screen, shorts, in the bottom right. Very surprising that they would put a purely descriptive word.
Which page are we looking at?
Sorry, the third page fourth page in this clip.
Fourth page.
Yeah, Bondi Beach, you see above that, shorts. Not all the clips have shorts as a bug. I think it's called the on-screen graphic, but some do.
I'm afraid I'm not with you, Mr. Barnage.
Oh,
Looking
do
at-
you see a
looking at
picture of a
the fourth
surfer?
page.
You see a surfer?
I can see a surfer and it says Bondi Beach.
Above that, you've got shorts. You've got two people on a surfboard, or two surfboards, it looks like.
Oh, I see the picture above, not in the picture, the one above it, and there's a black
There's a black tag,
rectangle and it's a white
Yeah.
word shorts.
and I think that's the logo as well
What do
next
we
to it.
call that, a bug?
I think it's called a bug. Sorry, I didn't mean to use film jargon. Next page I'll come back to. So I wanted to show you the smart TV, which I think is, yes. If you go a few pages forward, you'll see one that looks a bit like that, a picture of a TV set. And this one has a black and white version of shorts in the top left-hand corner. And I think these were from this was Google's ad. So it wasn't, where's the mobile phone screen stuff? It's the mobile phone in the middle. That's mobile phone, yes. Sorry, I've skipped over an important one, which is the principal form, which is the mobile phone use. If you just go to the penultimate page of this, you can see what is, we say, very important.
Penultimate page,
So the penultimate page,
that's the one you just showed us with the smart TV.
no, I think it's the, sorry, I've lost my place. I should have paginated these, I apologize. So do you see, there's one that has a picture of Chanel eyewear on the top left. It's a close-up of, so it's page 6 if you count from the front.
Right, and it's got Rockefeller oysters or something.
Yes, recreating an oysters Rockefeller recipe down the left. Those are, those look like, no they're not, maybe YouTube. But anyway, the one on the right is the one that matters. That is a picture taken from a mobile phone screen. And there's no YouTube logo on it anywhere. It says shorts in the top left-hand corner, and below that, in the bottom menu, again, shorts in black and white. Now, the significance of this was dealt with in the judgment. We contended that this was a very significant layout because these are, it was appropriate to consider two users, for example, two teenagers sitting on a park bench. One of them shows the phone to the other, and this is the screen they see. No YouTube, only shorts, and a classic example of post-sale confusion, which has been obviously dealt with in the court, in the Supreme Court in Iconics. But this was a good example, and the judge agreed with that, I should say, as a principle. Whether he didn't agree that there was confusion, that was the problem. And he held, if I can just show you the relevant passage. This is where he holds, are you talking about that? Yes, that's the one I'm talking about, yeah. Okay, good. So page 6, it's the passage bridging 64 and 65, paragraph 229. And actually, no, if you pick it up on page 65, and the passage that begins, but on other occasions the screen does not contain any either of those. So what he's saying is, Most notably, when the user is scrolling through the Shorts feed, see the illustration on the left in paragraph 15 above. For the reasons I've explained above, I do not think it's right to take into account as part of the context of that use the fact that the user accessed Shorts feed through the YouTube app and via the home page of the app. In any event, I agree with SIL that it's entirely realistic that some consumers will be shown another screen with the Shorts feed already open. Such consumers will not have seen the YouTube name or logo. So this was an upfront in your face, as it's put memorably by Justice Jacob, trademark use. This is a logo, it's a sign, and it is distinctive. So notwithstanding the said to be descriptive nature of the word, this was distinctive use being made. Now obviously the position in trademark infringement is normally assessed at the beginning of the act complained of, but if the position is that the defendant has used it as a trademark, it doesn't lie in its mouth to say, oh no, it's descriptive, when it has made distinctive use to a very great degree, as I indicated at the outset. If that were the case, then one would have expected this word to have become entirely generic when used in relation to short-form video content being shared on the internet and by other users. No, not a bit of it. It means the YouTube service. It distinguishes the YouTube service, and it's a badge of origin. My lord, that was similar to the position being used by TikTok and Instagram Reels. I mean, Instagram came up with Reels, very similar in my submission. Word from the film world that relates to elusively something similar to what they're doing, but is not descriptive, and they don't use it descriptively. Lord, I don't know if there was if we're having breaks for the shorthand writer or I don't know. Right. So the next big point was the judge's error when it came to descriptiveness. Assume against me that it is descriptive, or that at least it lacks, my mark lacks distinctiveness, and you've got to assess that and factor it into your analysis. As I indicated at the outset, you must follow the structured analysis, and you have to make sure that any descriptiveness is factored in the right way in relation to the right goods and services and as a factor along with other factors. Now, the starting point is to look at the judgment when the judge is comparing the marks. So if you please turn to start by identifying the sign. So it's 65 page number, paragraph 232. I mean, he's been looking at the various signs in question, and this is a section headed Comparison of the Marks and the Signs. I shall start with the 615, 649 marks. There's visual similarity between those marks and each of the composite signs used by Google, in that both contain the word shorts, and save in the case of YouTube shorts and the combination of the right in the right, a play symbol. There are also visual differences, most notably that the play symbol is contained in a separate logo rather than in the O of the word shorts itself, or that the word shorts is accompanied by YouTube, both of which make a difference to the overall impression. oral similarities and the composite signs between the marks and the composite signs are obvious, although the similarity is reduced in the case of the combinations which include YouTube. The conceptual similarities are also obvious, given that each contains the word shorts and a place symbol. And this is the part where he allows his assessment of distinctiveness into the comparison. However, as I've explained, the word shorts is descriptive of the type of material. Query what material it is said to be. And the play symbol is an indication that the material can be played. So the similarities are at a level which differs from that which has given the 615, 649 marks their distinctive character. So the earlier marks get the descriptive word excised from the analysis, and the later signs do too. And that results in a, we say, flawed comparison. Because as a matter of comparison, he should have stopped before the words however, for the reasons I've explained. Now,
Mr. Milanich, I'm sorry this isn't on the point you're asking about, but I've just read something which I'm now confused about. This paragraph 232 refers to the 615 marks, 615, 649,
yes,
which I think are the marks that have Shorts TV. It doesn't mention TV, and that's why I was. It's only paragraph 27 of the judgment shows that the 615 mark is the one that says Shorts TV.
yes.
Maybe that's where it's gone wrong. What then happens, because there's no mention of TV in 232, the comparison.
We think there might be typographical errors.
Well, it may well be a typographical error, but I just want to make sure whether there is one, and if there is,
Yeah,
what
there
is
were
it?
2 marks for shorts and
Yes.
2 marks for shorts TV.
234 suggests you have to read it.
Yeah, 234 does the other 2 marks.
Yeah, but it
It says that the absence of TV, which makes me think that in the way the judge is referring to it, 656 and 664 are the ones with TV in them.
Yes.
So they're not, they're the ones without TV.
So, Learned Junior points out that 239 contains a typo.
Yes, and 239 has the same typo.
But what he's saying is our best case is non-TV marks. Now, to some extent, it's the best case on a strict mark for sign comparison because there's no TV word in the Google use.
Yes, but your best case isn't the 615 marks, it's the 656 marks.
Yeah, I mean,
But your best case is 232, as I understand it.
is 232. Yeah. Well,
On the point you're making about about very sensibly, if I may say so, recognising it may be a small point, but you have a better case with a mark that doesn't have TV in it,
yes, strictly speaking, yes.
strictly speaking.
On validity, I have a better case
At this
on
point
TV.
at this point in the judgment.
Yeah.
And that's para 232.
Yeah.
But it starts by referring to 615, 649,
Yeah.
which are not the ones
Correct.
that lack TV. So there is something that's gone wrong. I'm sure it's just a
I think
typo.
it is just a typo. Because it's clear he's talking about the non-TV mark there.
Yeah.
Yeah. He then later goes on to consider the TV mark.
Yes.
So, I mean, it's a simple point there, but we say it's against a wealth of authority. Now, can I just show you the L'Oreal case, which is in tab 5, the bundle of authorities. And paragraphs 40 to 43, although that's all standard. Yeah. Picking it up at 40, page 120 of the Joint Authorities bundle. In the first place, it's settled case law that in order to assess the degree of similarity between the marks, it's necessary to determine the degree of visual, oral, conceptual similarity to determine the importance to be attached to those different elements, taking account of the category of the goods or services in question and the circumstances in which they are marketed. That's really very important. It's the factor that's mentioned in the statute, as I've mentioned before. In addition, the global assessment of the likelihood of confusion must be based on the overall impression. Tab 5, page 120. Bearing in mind their distinctive and dominant components. 42, it follows that the distinctive character of the earlier mark cannot have the significance which the applicant argues it should be given in the comparison of the signs in question, as it's not a factor which influences the perception which the consumer has of the similarity of the signs. Now, this is important because, of course, big trademark owners like to argue that their signs are more similar, or the sign is more similar to their highly distinctive mark as a matter of comparison because of their enormous reputation. That is illegitimate, and equally when it comes to low distinctive character. And that's because it's not a factor which influences the perception on similarity, which is a relative assessment on visual, oral, and conceptual. And that is a misconstruction of the concept which govern the determination of the likelihood of confusion.
But how can you do conceptual similarity without taking into account what the words mean?
You must take into account, and you must say, they both mean X. As a matter of comparison, you're not going to be ignoring distinctiveness, my lord. No one's suggesting that. It's a question of approach, because then you've got to say later, despite the conceptual identity that there might be between VapeCo and the VapeCo, and despite the visual and oral high similarity, because of the lack of distinctiveness, I'm going to find there's no likelihood of confusion. But you've got to give those factors their due, because otherwise they're simply ignored. And it's not pedantry. This is the principled approach. I mean, one of the cases I was going to take you to, the China Construction Bank case, which again shows that high distinctiveness can't be imported into the sign comparison any more than low distinctiveness. The Adidas and marker mode case is the next one I wanted to show you. These cases are mercifully quite short. And that's tab 6. The significance of this case was the argument, again often run by defendants, descriptiveness has to be given a proper scope, and it does. It can come in on validity, it can come in on infringement, it can come in on a defense, but it can't be overweighted. It can't be turned into a super factor, sorry, is a better way of putting it. It can't be considered to be the only factor that matters, because you've got to weigh it against other factors. And in this case, 29 and 30 are the passages I wish to refer you to. So the likelihood of confusion depends on numerous elements and on the recognition of the trademark on the market, the association which can be made, degree of similarity between the marks and the sign, and the likelihood of confusion must be appreciated globally, taking into account all the factors relevant to the circumstances. 30, the fact that there is a need for the sign to be available for other economic operators to use, I've inserted the word to use, cannot be one of those relevant factors. It's apparent from the wording of Article 5.1b, which matches Section 10.2, that the answer to the question whether there's a likelihood of confusion must be based on the perception of the public of the goods and the goods covered by the sign. Moreover, signs which must generally remain available for all economic operators are likely to be used abusively with a view to creating confusion in the mind of consumers. So this point is obviously an important point when it comes to validity. Public interest is, it's clear, and it's an important point when it comes to the defence of honest practices on which Google failed and didn't appeal. but it can't come into your thinking when it comes to this. I'm not saying that the judge did, but the increasing and regular insertion of distinctiveness and descriptiveness throughout the judgment suggests a sort of over emphasis on that, and also a doctrinal error when it came to factoring in.
Just a minute, Mr. Mullins.
Yes.
I thought you showed us in L'Oreal that although distinctiveness or descriptiveness wasn't to be taken into account at the level of deciding on similarity, it was part of the global assessment. But this marker mode seems to be saying it's not even part of that.
No, it wouldn't be part of that because it's expressly only part of the validity analysis, the public interest. Because I think
No, not the public interest. I'm not talking about the public interest.
the
I'm
need
talking
to
about
keep free. I mean,
descriptiveness.
so I'm sorry.
Descriptiveness.
Oh, descriptiveness. No, I don't think that is what the Adidas case court is saying. I think the Adidas court is saying simply that the argument that it must be kept available for other economic operators to use, a sort of public interest in keeping it free, that can't be part of the
Oh, I see.
I think
that's the
it's quite a
reason
narrow
why you
point.
don't have and that's what's wrong with descriptive trademarks. But you say but they're not talking about the inherent descriptiveness itself. They're just talking about that particular policy factor. You don't take that into
Exactly.
account.
And I mean, I'm not accusing the judge of having illegitimately
Yeah, I see.
taken into account. It really is just to show the boundaries. The other point is in tab 17 of this bundle, again quite a short judgment, and this was. I mean, this case gives serious doubt, or places serious doubt over the whole approach of discounting or airbrushing out descriptive elements when it comes to the assessment of the likelihood of confusion. Why do I say that? Because it's quite a stark both analysis and result. This is a judgment of the Grand Chamber of the Court of Justice, and the marks were compressor for, here they are, so background of the dispute 461. The application for registration was compressor technology for various class 7, 9 machines, so on. And the earlier mark was compressor with a K for various electronic and kitchen machines, washing machines and so on. Pretty descriptive in relation to both mark and sign, and the approach of the court was to say, if you pick it up please at 58 to 60. They refer to BSH's argument, and I think it's important to just understand what the BSH argument was. That can be seen from 47. By its second plea, BSH pleads an infringement of Article 8.1b, the equivalent of Section 10.2, criticising the General Court for having relied in particular on an erroneous understanding of the concept of a likelihood of confusion, the effect of which, when two trademarks coincide as regards a purely descriptive element, that is sufficient to give rise to a likelihood of confusion, thereby leading to the monopolization of a purely descriptive indication, a situation which Articles 7.1b and c are intended to prevent. So that's the argument that they are dealing with. In BSH's submission, where the earlier mark is a readily recognizable variant of a descriptive indication and the later mark contains the descriptive indication itself, even the existence of major similarities between the signs and the goods, which the opposing marks
I lost
come.
you, Mr. Mullins.
I'm sorry, my lord. It's 48, 47 and 48.
Right.
So I flipped
These
back.
are the arguments.
This is the argument, just to understand what it is they're dealing with, 50, 58, 59. So it's very similar to the approach taken by the judge, in short. In BSH's submission, where the earlier mark is a readily recognizable variant of a descriptive indication
and the later mark contains the descriptive indication itself, even the existence of major similarities between the signs and identity of the goods are not capable of permitting the conclusion that there's a likelihood of confusion if the similarities of the signs are limited to the descriptive indications and concern only goods which are described by the indication. Critical point, the public does not perceive any indication of origin in a descriptive indication, but is guided by the other elements of the mark. Furthermore, according to this argument, the extent of the protection of the earlier mark is not limited generally, but only as regards the descriptive indication itself. So it remains intact in relation to other goods and services. So what they're saying is, you can't find a likelihood of confusion if the similarities are limited to the descriptive indications and concern goods for which those indications are descriptive. Now, the General Court answered that by saying that to accept BSH's argument would have the effect of disregarding the similarity of the
You're now on
marks.
58, are you?
Now on 58, yep. And this is the part we particularly rely on. That argument would have the effect of disregarding the similarity of the marks as a factor in favour of the factor constituted by distinctive character, which would thus be given undue importance. The result would be that where the earlier mark is only of weak distinctive character, a likelihood of confusion would exist only where that mark was reproduced in its entirety by the mark applied for, depriving the degree of similarity between the signs in question of any significance. That result would not be consistent with the very nature of the global assessment which the competent authorities are required to undertake. So BSH's arguments relating to the weak distinctive character of the earlier national marks could not affect the conclusion of the Board of Appeal. That approach is not vitiated by any error of law. And then 61, even though essentially the Court of Justice has already held that the distinctive character of the mark must be taken into account when assessing the likelihood of confusion globally, it is, however, only one factor among others. And although the more distinctive the earlier mark, the greater the likelihood of confusion, such a likelihood of confusion cannot be precluded where the distinctive character of the earlier mark is weak. Now, I think they repeat the point in 64. The part that I wanted to focus on was the result would be, in 58, that where the earlier mark is only weak distinctive character, a likelihood of confusion would exist only where that mark was reproduced in its entirety by the mark applied for. That's in effect what the judge held here. Because the judge held that when it came to infringement, aspects of stylization which could have no effect on, for example, oral similarity or conceptual similarity, were sufficient to avoid a likelihood of confusion. So one is asked, one is compelled to think, what would have infringed? Well, the plain word shorts, perhaps, or the plain word shorts, as the judge said, where the place symbol was placed inside the O, and then you're dealing with identicality. And that is, that's the vice, that if you simply airbrush or downgrade to the point of irrelevance the similarity of what are obviously the dominant, graphically dominant aspects of the sign, then you are promoting distinctiveness into a superfactor. You are focusing on an exercise on distinctiveness which isn't one necessarily performed by the average consumer, and overall taking the wrong approach. And we've seen, most importantly, that the judge allowed this to pollute the comparison exercise.
So just to understand where that's going, are you effectively saying you should have found a higher level of similarity than you did?
Well,
because he wrongly ignored.
so I say he made an error in his approach and therefore allowing the court to substitute its own view. So I don't simply challenge, I don't want to be heard to be saying he should have placed more weight on similarity, because that would be simply an attack on his multifactorial assessment. No, because, but he made an error of law by skewing comparison with distinctiveness considerations, which I hope I've made clear that should not happen. And so as a result of that, that's an error of law, and the court's hands as to what happens next with that. But essentially we say he should have performed the exercise properly, yes, and he should have held.
Well, put it another way, what was your case below?
Yes, so my case was there was high similarity between the marks visually, orally and conceptually at the stage of comparison. And then when it came to overall likelihood of confusion,
That then feeds in.
you got into distinctiveness there, but it was not enough to, and so on and so forth. So,
Does the judge decide a question like there is high or low similarity?
no. And that's in a sense one of the problems of the approach, because
It might be said to be one problem with your argument, isn't it?
well,
Because
if you look,
if he'd said, your point, as I understand it, is he said he made an error of law, which meant that he found there was a low similarity when there should have been a high similarity. But if
well,
he
it was
didn't do
worse than that. It was worse than that, because in the paragraph I took you to, he essentially, so he compared, there is visual similarities, 232, there is visual similarity, there are also visual differences. So he's at this stage just identifying them, then there's oral similarities, and then conceptual similarities. And then he says, however, for the reasons I've explained, the word shorts is descriptive and the place symbol is an indication that material can be played. So the similarities are at a level which differs from that which is given the 615 marks in their distinctive character. I mean, there could not be a plainer assessment of the comparison by reference to distinctive character. That is the essential mechanic that is identified. Whether you call it airbrushing matters not. It's simply part of the judge's approach. Now, he also then went on to consider the 383 mark, but I wanted to deal with that completely separately if I can, on the TV mark. The play symbol. Now, can I just be clear on how the judge considered that there was sufficient to avoid the risk of confusion between these marks? We say, in essence, that the judge held that the fact that the play symbol within the defendant's signs was not within the letter O of shorts and was instead in a separate logo placed within the logo was sufficient to dispel confusion. We say that finding is rationally unsupported. That's, I think, the only challenge we make to the facts on that basis. But we say that is. It's a critical part of the judge's reasoning. It's rationally insupportable because, if I can just identify the sign we're talking about, if you look on 67 of the judgment, paragraph 240, that's the one right here. Now, and you take one of the shorts marks. So if you look on page 10 by way of comparison, the trademark, the top one, is black, so sans serif font, all caps on a white background with a red play symbol within the O. And this is being compared, I'm not sure why this one's
So this is 656 you're talking about.
656, yes, my lord, the top one. And that's being compared with the black and white version of shorts. That's the one that the two teenagers on the park bench will, so it'll be on the screen, at the bottom of the screen. Now, if you have that open, I mean, that print, by the way, is more or less about the size of a smartphone. I don't think it's deliberate, but I think that's about the same size as a smartphone. Now, the judge is basically saying that the consumer, ignoring the identical word, and ignoring the fact that there actually is a place symbol, which they are taken to be familiar with in the earlier mark, remembers and notices that at the bottom of that page, it's not within the letter O, and that is sufficient to avoid a risk of confusion. And that's the one we challenge on the basis of rational insupportability. We do that for a number of reasons. First of all, it's so small, the word shorts there, that I don't think any consumer would suppose there was anything in the letter O, if indeed they remembered that at all. Far more important are the words shorts, identical, the fact that there's a place symbol in a logo. And that, we say, is far more significant, but it was insufficient to militate against any risk of confusion for the placement of the place symbol play such a role. Yes. Yes, I'm reminded that there were, of course, other signs in issue. I've focused on the post-sale confusion sign, just because that is the dominant form of use, the scrolling screen of YouTube Shorts. If you look on page 9, so the page before the signs we were looking at, you can see those signs. Shorts were sometimes put next to the logo. Sometimes the logo is red, all red. Sometimes it's red and white with the white play button. Sometimes it has the TV screen or YouTube logo. Sometimes in white on black, sometimes in black and white.
Do you anywhere complain about shorts, the word without a logo? It looks like it's always with something.
No, we did complain, my lady, yes. And that's pleaded. I mean, we do say that it's recorded in 23 of the judgment, just above that.
Oh, yes.
That includes the use of the use of the word shorts alone and alongside the YouTube. Now, in relation to these uses where there's a logo and a word, we say that's use of the word alone. I mean, it has a different semiotic value in the consumer perception. So you've got a visual graphic and you've got a word, and they have a different role. So the judge's approach of considering these as composite signs was, we say, subsumed our focus on the use of the word shorts. But there were also uses of shorts, and my Lord Justice Burst referred to the down the menu items, down the side. So if you look at the printout that I handed up, you can see there was a debate and a finding against us in relation to the creator pages. And the example of that is the 3 or 4 pages in. You've got the Pixar creator page. You've got some Disney Pixar characters and puppets and so on. Creator page is a rather fancy way of describing things. Anyone who uploads a video is a creator to this service, and so they get a similar page every single video that's handed up, that's sort of uploaded. And this page is only accessed by the YouTube and then Shorts pages. And it has home, videos, Shorts, live, playlists, community. Well, there's only one word there that's distinctive, we say, the word Shorts. This wasn't the only example of soulless use, by the way. This was just the ones that the judge considered, and he regarded this use to be non-distinctive. Yes. On that very page, you've got on the left Shorts with logo, with a play symbol, and of course you've clicked on that.
What's called a logo? It's not necessarily a logo, is it? If by logo you mean something with trademark significance, it's an icon. It might or might not be a logo.
Yes, it's a picture at one level. It's a
It's a picture,
device,
exactly.
yeah,
No, I know.
It's a
You
picture.
called- I noticed you called it a logo all the time, Mr.
Yes.
Mallich. And for example, beside the word home is a little house.
Yes.
Is that a logo?
No, that's an icon. That's a generic icon.
Exactly.
But equally, when you look over the page,
No, I understand. In other places you say.
yeah, no pages. Now the judge has blown up the graphic of the post-sale confusion page, as I call it, so that you can clearly see that it's got a play symbol there. This is a little sign at the bottom of the page in one instance, and it's a big sign at the top in colour with the word shorts. And we say
Where are you now?
I was comparing the two signs, so I was showing you the, sorry, hold on. I was comparing the trademarks which are on page 10 with the printout, or you can, sorry, 67, with 67, which is the blown up version of by the judge, of what is on the bottom of page of the mobile phone screen in the handout that I gave you. And obviously in real size, it's quite small. We just say it's a matter of perception. The consumer would not notice. But I think I've been through this point on rational importability. I hope I don't want to repeat myself. The TV marks. Now there are two stylized TV marks. Look at them. Here. Yes, on page 9, bottom of the page. I mean, what's striking is the similar overall colour scheme, I have to say. I mean, leaving that aside. The Shorts TV, two Shorts TV marks, 615 and 649, which are registered for the same goods and services. But there was also a Shorts TV only, word only mark. Now, it makes sense to focus on that because, of course, aspects of stylization don't strictly form a part of the analysis when it comes to a word only mark. I mean, there may be an extent to which Google's word is got up and stylized in a way that takes it away from a word only mark, but that's not the case here. Word shorts was always plainly presented by Google, notwithstanding that it may have had a fancy logo next to it or another word. So the analysis on infringement is obviously not as close as Shorts and Shorts TV, but in my submission it is still close. And of course the issue of stylization cannot assist Google. So the question for that one is, first of all, the judge invalidated it, and I've got to try and resuscitate it. Now, we say that the judge wrongly assessed distinctiveness when it came to Shorts TV. I mean, this was just a plain error of approach, because Technopol says you've got to understand whether that term will be seen as describing a characteristic of the goods or services. In the judgment, the judge analysed the submissions that were made and simply considered that Shorts TV was a straightforward combination of two non-distinctive words in a resulting whole that did not have any distinctiveness about it. However, he didn't ask himself the basic question, which is its suitability as a descriptive term for any of the goods or services. And that's the ultimate question. It isn't simply an assessment of the individual elements and whether they are put together and packaged in an innovative way. Ultimately, the question is this a descriptive indication? We say there are two reasons why it isn't. The first is that the relationship, I'm going to try and avoid grammar or syntax, just the relationship of the two elements gives rise to a whole which cannot conveniently be used as a descriptive term for any of the goods or services. A film is not described as a shorts TV film. The entertainment service is not described as a shorts TV service. And the telecommunication service or the computer software cannot conveniently be described as a shorts TV. It can't be used adjectively. Now, at some level, it might be said, well, it's not confined to adjectival use. It can be any form of content. And that seems to be the principal objection under 3.1b and c when it comes to validity for shorts. But that doesn't apply to shorts TV because shorts TV doesn't describe the content. You're not going to say generically, let's watch some shorts TV tonight. You might be saying, let's watch something on shorts TV. But that brings in my second submission, which is that, and there was evidence in support of this, the consumers have learned to understand that an elusive or descriptive even word, allied to the word TV or the element TV at the end, generally indicates a specific channel about whatever it is that subject matter is. That does not make the whole descriptive. On the contrary, it is akin to a proper name. It's like putting limited after it or Mr. before it. It turns it into something specific. It has a specificity to it. And so whatever it is, it can't just be seen as an ordinary sum of the parts that doesn't add anything. It does add something. Now, I don't want to turn to the evidence on this, but this was a point that the judge didn't seem to explain. If you can look, please, at paragraph 112 of the judgment, where the judge analysed this. Because it contains some difficulty with my submissions, perhaps if you just read it to yourselves. So the judge's reason for disagreeing with that was that without use, consumers would not assume that that did indicate a particular channel. But that didn't meet the point, because that's begging the question. That obviously, if it needs use to be registered, it's inherently unregisterable. So that's just simply restating the objection. But it also doesn't meet the point because we weren't relying on our own use of shorts TV. Well, we were separately, but on this particular argument, we were relying on a general consumer understanding in relation to other traders and the structure of the mark itself.
Isn't the point the judge is making that he's taking your submission that people are used to seeing the word TV added to something as being a reference to something, and saying, but it doesn't have to be the name of a particular channel, it could be a type of content.
It may be a type of content in some circumstances. So I think we accepted that, for example, news TV or something very generic like that might be. Shorts TV. I mean,
That's the point the judge is making. Why is he wrong?
because it depends, you've got to look carefully at the propensity of the word to be understood as a descriptive indication according to technical. It must be reasonably likely that it'll be actually understood. And I mean, as a matter of fact, first of all, there aren't any other shorts TVs. There aren't any other channels devoted to the short film genre, much less any others with shorts in their name. And indeed, there are a plethora of programs or channels on the EPG that use fashion TV and Liverpool FC TV and so on. So we've got an ordinary custom or practice of consumers seeing that with the result that that's their general understanding. I mean, the point actually has been endorsed. I mean, it's, to some extent it's a factual point, but there is a little bit of law on this point. If you take, please, the Bundle of Authorities, tab 2, the case before the Court of Justice in SAT.1 satellite, Furness and GmbH. This case was concerned with the application to register, I believe, SAT.2 for a television channel. Yes, it's in paragraph 20.
Sorry, can you give me a
It's tab 2 of the Bundle of Authorities and page 57. Secondly, the appellant claims, after observing correctly, that it was necessary to examine the overall impression made by the term SAT.2 on the consumer in order to assess whether the sign had distinctive character. This was without evidence of use, so this was an inherent distinctiveness case. The Court of First Instance did not apply that rule of analysis correctly in the present case. Instead, it broke down the term into its constituent elements in order to found its refusal to register. However, such a breakdown is not the way in which consumers appraise and interpret the trademark when they perceive it. Moreover, the Court of First Instance wrongly based the absence of distinctive character on the fact that the term was composed of elements commonly used in trade, SAT, being satellite too, for the presentation of the goods and services concerned, whereas that kind of element can be taken into consideration only when applying Article 7.1c. The Office responds, that's not the passage that I wanted. This is the Office who regarded that it was, sorry, this is the argument of the parties, it's the, yeah. Is that far? I thought there was more already. Yeah. If pick it up at 43, please, on page 63. In this case, the Office merely stated in the contested decision that the elements SAT and 2 were descriptive, and in the current usage in the sector of media-related services, without stating in what way the term SAT2, taken as a whole, was not capable of distinguishing the services of the appellant from those of other undertakings. The frequent use of trademarks consisting of a word and a number in the telecommunications sector indicates that that type of combination cannot be considered to be devoid in principle of distinctive character. We would replace that with the frequent use of trademarks consisting of a word plus TV in the telecommunications sector indicates that that type of combination cannot be considered to be devoid in principle of distinctive character. It may in any particular case, but the judge didn't, in this case, explain why Shorts TV would be considered to be a lack of distinctive character.
Mr. March, paragraph 112 of the judgment that you were referring to, the judge
Yes.
records your submission as
Yes.
submitting that when consumers were used to TV channels being named XTV when X was a reference to the type of content.
To refer to a particular channel.
Well, that's why I'm asking you about this, because what you're saying you said and what he's written down is not the same thing.
I think we got into a bit of a bind over what the significance of syntax. My lord may
No,
recall.
I'm not talking about syntax.
Oh,
I'm
right,
talking,
yeah.
my point is, the judge has recorded your submission as being X was a reference to the type of content. And there is a difference, which is the point the judge makes at the end of that paragraph, between a type of content and a particular channel. Now, as I understand it, you haven't told us that he misunderstood what you said, but it seems to me if that's the point you were making, then I can't see what's wrong with the judge's response.
Because the submission, I don't think he did understand what I was submitting and what I'm submitting now. The point is that it is not simply that the individual elements are descriptive, or that there's any requirement that they be put together packaged in a clever way or striking way to make some sort of neologism or some sort of portmanteau term or something. It is simply that this formula indicates specificity and a capacity to distinguish. It's a bit like if you put the word limited, budget limited, to take an extreme example, the word budget doesn't indicate anybody, but budget limited can indicate a particular company called Budget. Obviously there may be many of those companies. We're talking about the EPG here. How many channels can there be on an electronic program guide? We say consumers are not used to seeing multiple channels with the same formula, XTV, whether it be fashion TV or music TV, whatever it might be. They're just not used to that. They're used to seeing one, even if it contains a descriptive word. And so that particular formula, we don't need to call it syntax or anything like that. That particular formula has the function in consumers' minds as a starting point of indicating a single channel. Now, there may be examples where sports TV or maybe music TV even, compared to MTV, where there is a generic meaning. But tellingly, the judge didn't grapple with any of that here. He didn't grapple with shorts TV. He just said, that does not mean that without use they would assume it did, and the evidence did not establish that they would. I don't want to go island hopping, as it's sometimes called, through the evidence, but there was evidence that baby TV would be distinctive from one of the Google witnesses, that lady in marketing, and there were plenty of examples, both pleaded and in the evidence generally, of numerous channels of this formula. Not the only formula, numerals as well is another way of indicating ITV1, ITV2, ITV3, whatever. But this is a formula that is recognisable, and it's appropriate for it to be given some different scope when it comes to these goods and services.
As far as I can see, he starts answering this in 111, and what he says there is quite significant.
That's right.
I mean, he's basically saying it's on the music, to take your example earlier, isn't he saying it's on the music TV side of the line?
What he's doing there, my lady, no, he's not. What he's doing there is he's simply stating the legal test, because that is the legal test.
No,
And
he's not. He's trying to, he's explaining why he thinks.
Yeah, but the point is he's put that in quotes, and you need to look at post-cantur to see that the test, because in fact I had intended to take it. That's bundle 1 of your list of authorities. So it's a short passage where this is the part he's talking about. If you pick it up, page 35, the bundle of authorities.
He's quoting from the case.
Yes, he is. And but he's only quoting the first part, the classic part, the sort of default position, which is that in general, where a sign is composed of non-distinctive elements, putting them together doesn't create a distinctive whole. But there are caveats to that. So if you look at the passage bridging 36 and 37 of the Bundle of Authorities, tab 1, a mark consisting of a word composed of element, each of which is descriptive, is itself descriptive of those characteristics, unless there's a perceptible difference between the word and the mere sum of its parts. That assumes either that, because of the unusual nature of the combination in relation to the goods or services, the word creates an impression which is sufficiently far removed from that produced by the mere combination of meanings. That I take to mean put together cleverly or put together in a new way, with the result that the word is more than the sum of its parts, or that the word has become part of everyday language and has acquired its own meaning, with the result that it is now independent of its components. In the second case, it's not necessary to ascertain whether a word which has acquired its own meaning is not itself descriptive for the purpose of the same provision. This case doesn't fall comfortably within either of those, but it's closer to the second. What they're saying there is they're acknowledging that there may be a sort of, it becomes a term of art in some sense. And that's more or less what
Well,
we
you're
were,
effectively saying, at least to some extent,
is the second.
word X or anything TV is
Not anything, but yes, close to it. I mean, I'd be happy with anything, of course. But yes, certainly it can be the case depending on the type of word. And it's that part that wasn't echoed in the judgment awards. Maybe would that be a convenient moment to move on to a different point?
Very good. All rise now and see you at 2 o'clock.
Court rise if able.